Welcome to The Explainer. Today we are diving deep into the high-stakes battle over Colorado's landmark artificial intelligence law. It's a really fascinating story about innovation, regulation, and a major political showdown that could literally redefine how your business uses AI.
So, what happens when the very first comprehensive state AI law in the nation goes head-to-head with a presidential executive order? Now, this isn't just some abstract legal debate for politicians to argue over. This has real-world consequences for every business trying to plan for the future. So, what does it all mean for you? Okay, let's break it all down.
All right, here's what we're going to cover. We'll start by looking at how this groundbreaking law got put on pause. Then, we'll get into the nitty-gritty of what it actually demands. After that, we'll unpack the big state versus federal showdown, explore why getting ready for this law is still a really smart move, and we'll wrap it all up with a practical checklist to get you started.
So how in the world did we get to this point? Well, our story really kicks off back in 2024, with a piece of legislation that was poised to change absolutely everything for AI in the United States.
So, back in May of 2024, Colorado basically made history. They passed Senate Bill 205. And the goal? It was simple, but, wow, was it ambitious? To be the very first state to comprehensively regulate high-risk AI and to protect consumers from, algorithmic discrimination in those big, life-changing decisions. But the ink was barely dry on the bill before the opposition really started to build. Tech leaders, business groups, even the governor himself started voicing concerns that maybe the law went too far, that it might stifle innovation. So, after some pretty intense lobbying, a special session was called in August 2025. And you know what? Lawmakers couldn't agree on how to change the law, so they just settled on the one thing they could agree on, kicking the can down the road and pushing the start date to June 30th, 2026.
Okay, so the law is delayed, but it's still on the books. So what does it actually say? These are the rules businesses really need to get their heads around, so let's unpack the key requirements.
Now, the first thing to get is that this law doesn't target all AI. It's laser-focused on what it calls high-risk AI systems, basically any system that's a major factor in making what the law calls a consequential decision.
So what exactly are these consequential decisions? We are not talking about the AI that picks your next song on Spotify. No. The law is focused on the heavy stuff, the crucial, life-altering areas. Things like getting a job, securing a loan, accessing healthcare, finding a place to live, and a whole lot more. If your AI touches any of these areas, this law is definitely for you.
The Act creates two distinct roles, each with its own set of rules. On one side, you've got the developers. These are the folks who build the AI. They have a duty of reasonable care to prevent discrimination. And on the other side, you have the deployers, the businesses that actually use the AI to make those big decisions. They're the ones who have to set up risk management programs and be transparent with their customers. Now, for the deployers, the absolute heart of compliance is the impact assessment. Before you even think about launching a high-risk system, you have to do a deep dive. Analyze its purpose, the data it's using, the foreseeable risks of discrimination, and exactly what steps you're taking to mitigate those risks. And listen, this is not a one-and-done thing. You've got to do it every single year. Okay, so just as businesses were starting to wrap their heads around all these new state rules, things got a whole lot more complicated. A major intervention from the White House came out of nowhere and threw the entire future of AI regulation into question. So, in December of 2025, President Trump issues an executive order, and it is aimed squarely at stopping states like Colorado from creating their own AI rules. The order specifically calls out Colorado, arguing that its law could actually force AI to produce inaccurate results just to avoid discrimination claims.
Well, the response from Colorado was, let's just say, swift and defiant. The Attorney General, Phil Weiser, immediately declared the federal move unconstitutional and basically vowed to defend the state's right to regulate in court. And just like that, the stage was set for a massive legal battle.
And the core of this whole conflict really boils down to this. Colorado's law is built on preventing discriminatory impact. It doesn't matter if it's intentional or not. The federal order, on the other hand, wants to get rid of that legal theory entirely. And while Colorado can hit you with big fines, the federal government is threatening to withhold critical funding. We're talking about money for things like rural broadband. It's a classic constitutional clash over states' rights and who really holds the power to regulate new technology.
So, with all this legal chaos and political uncertainty, you're probably asking yourself, why should my business even bother preparing for a law that might get completely overturned?
And you know what? That is a totally fair question. But here's why ignoring it could be a really big mistake. First and foremost, the financial risk is very, very real. If this law stands and goes into effect, the Colorado Attorney General can fine businesses up to $20,000 for each violation. Think about that. Those numbers can add up incredibly fast.
But honestly, the crucial point here is that being proactive is about more than just dodging fines. It's about building a defense. The law has this thing called a rebuttable presumption. It sounds like a bunch of legalese, but think of it as a legal shield. If you can prove you've done your homework and exercised reasonable care, you have a really powerful defense against any legal action.
And beyond any legal defense, just think of this as a smart strategic investment. Colorado's law could very well be the blueprint for future state or even national regulations. Building a solid AI governance program now isn't just about complying with one law, it's about future-proofing your business. It builds trust with your customers, and frankly, it gives you a serious competitive edge in a world that is demanding more and more accountability.
All right, let's get practical. Let's talk about a no-nonsense plan you can actually use to get ready. And the beauty of this approach is that these steps will put you in a strong position, no matter how the whole legal battle plays out.
Okay, first things first. Take an inventory of your AI systems. You have to know what you have. Next, figure out your role. Are you a developer or a deployer? Then, and this is a big one, adopt a recognized risk management framework. The law itself points you towards great ones from NIST and ISO. From there, start drafting your impact assessments and your consumer notices right now. And finally, get a system in place to document everything. These steps create a foundation for responsible AI that will serve you well no matter what happens.
And if you want to dig even deeper, a resource like this checklist from TrustArc is absolute gold. It really breaks down the key activities you should be doing right now to get ready for that 2026 deadline. Things like setting up a cross-functional AI governance team and actually training them on these specific rules. It shows that this is about building a real program, not just checking off a few boxes.
At the end of the day, this fight in Colorado isn't just about one state law. It's a preview of the incredibly complex national and global conversation around AI accountability that is just getting started. And that really leaves one final question for every single business leader out there. Are you ready for what's coming next?